Indemnities. Indemnity obligations to a customer should be limited to the extent of a contractor's negligence and be limited to death or injury to persons and loss of or damage to tangible third-party property, excluding the works. Limit indemnity to aggregate liability cap. Exclude liability for any owner's risks. Limit claims period, maximum equals end of warranty. Be covered by insurance, take advice from a broker if unsure. Indemnity clauses should be clearly worded and unambiguous to avoid any confusion or disputes over their interpretation. The indemnifying party should have the right to assume control of the defense and settlement of any claims covered by the indemnity, subject to the indemnified party's right to participate in the defense. Indemnity clauses should not be too broad, as this could potentially result in the indemnifying party assuming liability for matters beyond their control or expertise. Care should be taken to ensure that the indemnity provisions do not conflict with other provisions of the contract, such as the force majeure clause or the limitation of liability clause. Indemnity obligations should survive termination or expiration of the contract to ensure that the indemnified party is protected even after the completion of the project. Limitations of liability. An exclusive remedies provision limits the available remedies to those specified in the contract and precludes any other remedies that may otherwise be available under the law. An entire agreement provision states that the contract contains the entire agreement between the parties and supersedes any prior negotiations, understandings, or agreements, whether written or oral. Together, these provisions help to limit the potential liability of the parties and clarify the scope of the contractual relationship. The EPC contract can and should contain a general limitation of liability clause, as a separate article, and specify aggregate liability cap, maximum typically equals 100% contract price. Specify that the owner does not rely on any representations or warranties except as expressly set out in the contract. Can and should expressly exclude liability for all consequential losses. Loss of profits, loss of production, loss of contracts or loss of use. Special, indirect, incidental or consequential damages. Under all legal theories including breach of contract or statutory duty. Tort including negligence and strict liability and tort. Indemnity. And expressly incorporate. An exclusive remedies provision. An entire agreement provision. Sole exceptions. Fraudulent representations. Willful misconduct. Gross negligence.